Hello.
Good afternoon, sir. What is your name, please?
Jackson Ray.
Mr. Ray, good afternoon. You are before the court in 4 different cases, 25L000045 and 25L000965 are before the court for review hearings. There's also 25L004545 that is before the court for a pretrial hearing. And lastly, a new case, 25L004597, which is before the court for arraignment.
Yes.
Ms. Capone, have you had an opportunity to speak with Mr. Ray, or do you need a breakout room?
Your Honor, he was single cell, so if the court would entertain a breakout room, I would appreciate that.
Certainly. So, Mr. Ray, you may have to ask the officer to assist you, but we're going to go ahead and put you in a breakout room so that you can speak with your attorney privately before proceeding with your hearing, okay? And Ms. Capone, have you had an opportunity to speak with Mr. Ray?
I have, Your Honor, and we're ready to proceed on arraignment.
Thank you.
I've advised Mr. Ray of his rights, and I believe he understands them. Looks like the court found probable cause on August 23rd, so I'm not asking to be heard further on that. We asked the court to enter a plea of not guilty, and we're also waiving a formal reading of the complaint. My office represents Mr. Ray on all the backup matters, and I don't believe his financial situation has changed, so we'd ask for appointment without promissory note at this time.
Thank you. Mr. Ray, on the new matter that you're before the court for arraignment on, case number ending in 4597, court will waive formal reading, find that there is probable cause, and are pleased of not guilty to each of those 2 counts for you. The court will appoint the Horwath Law Office to represent you in that matter. The court will also hear from the prosecutor regarding the prosecution's recommendation on pretrial conditions of release. Mr. Graham.
Yes, Your Honor. Your Honor, obviously, as the court is well aware, we were considering Mr. Ray for community court and was expecting to be able to see Mr. Ray this morning to observe community court when he was picked up over the weekend. What's of concern to the city, Your Honor, is that we saw Mr. Ray in custody back on the 20th, so Wednesday of last week, where he was released with the idea of showing up Monday morning to then take part in community court. Now, over the weekend, he's at least alleged to have committed criminal trespass and resisting arrest. At this point, Your Honor, just don't have a whole lot of confidence that Mr. Ray is going to continue to remain law-abiding while on release by the in the city. So the city is requesting pretty nominal bail. We are requesting $500 cash or bond.
Welcome back to the courtroom, all right. Buckle up, because this one is a roller coaster. Mr. Ray isn't just facing one case, not 2, but 4 separate cases stacked against him. Today's hearing covers everything from prior reviews to a brand new arraignment, and the stakes are higher than ever. Already, we're hearing his lawyer ask the court for leniency, pointing out his financial struggles and pushing for representation without added costs. But here's the kicker. While the defense tries to position him as someone just trying to get back on his feet, the prosecution is armed with fresh allegations. Community court was supposed to be Ray's second chance, but instead, he's accused of trespassing and resisting arrest only days after his last release. That's the tension driving this entire hearing. Is Mr. Ray someone who can truly benefit from a second chance, or is he burning through the court's patience one case at a time? Stay with me, because the twists here are wild.
Bond, with no criminal law violations, and we're asking to be ordered to stay away from H&W Auto Sales.
Mr. Graham, you're requesting $500 cash or bond per cause. Is that correct?
Just on the most recent arraignment, Your Honor.
Thank you. Ms. Capone?
Your Honor, we'd ask that Mr. Ray be released on his own recognizance and be set to observe community court 2 weeks from now. Understanding the concerns that the city and court may have, we'd ask that there may be an intervening check-in with probation for next week. That way Mr. Ray isn't going too long without seeing the court. But these new allegations before the court are just allegations that he's entitled to the presumption of innocence on, the presumption of release on, and they are nonviolent in nature. So I do still think Mr. Ray would be a good candidate for community court, and we'd ask the court to kind of see it through, even if it means that Mr. Ray checks in with the court maybe more than most to start. He has indicated to me that he does have an appointment with South Sound Behavioral Health to be put on mental health medications for this Wednesday. I do think that would be very important for him to get to and might set him up for success going forward. So our request would be personal recognizance release. No objection to the other conditions outlined by the city, but I think Mr. Ray would probably do very well in a therapeutic court program if we can get him there.
Mr. Graham, I apologize. What was the name of the victim business that the city was requesting no contact with?
Your Honor, I have it down as H&W Auto Sales.
Thank you. Court is cognizant of the concerns that Mr. Graham has raised. There's a pretty striking pattern of new law-abiding behavior violations or allegations very quickly after the court releases Mr. Ray on personal recognizance. And unfortunately, that's just not something the court can ignore. The court's going to follow the recommendation of the prosecution. The court will impose a bail amount, a nominal bail amount, a total amount of $500 cash or bond on the new case as requested by the prosecution. Court will release Mr. Ray on his personal recognizance on the other matters. So total bail amount will be $500 cash or bond. I understood that to be the request of the prosecution, so I will follow that request. Now, Ms. Capone, that creates the question for you as to whether or not you think that bail is within reach for Mr. Ray. If you do, then I'm inclined to set this on the next community court calendar, assuming that is still the recommendation of both parties. If not, I can set it for an in-custody pretrial conference, whichever you prefer.
Your Honor, I'd be asking for both. I'd like to believe that Mr. Ray could post that bail, but I would hate for him to get lost in the shuffle if he doesn't. So perhaps an in-custody date of Friday, and then an out-of-custody date of community court if he posts.
Mr. Graham, is there any objection from the process? I know that that was something that you agreed to last Wednesday. Are you still willing to agree to Mr. Ray potentially observing community court?
Yes, Your Honor. Obviously, if we can get Mr. Ray engaged in treatment and then getting him into community court will probably be to his benefit and to the community's benefit. It's just getting over that hurdle is going to be pretty difficult.
I mean, sitting in jail for right now is benefiting that I can get out tonight and be by Tuesday to treatment.
So I agree with the sentiments that have been expressed by both attorneys. I'm going to go ahead and adopt the in-custody date that Ms. Capone has proposed. If nothing else, that'll put Mr. Ray back before the court, and so we can kind of reassess the situation this Friday at 11 a.m. If he does post bail, then his out of custody pretrial conference date will coincide with our next Veterans Court hearing, which is scheduled for September 8th, 2025 at 10 a.m. The other conditions the court is going to impose upon Mr. Ray are as follows. He is to remain in contact with his attorneys, appear on time and in person for all scheduled court hearings, have no criminal law violations, update the court of any change in his mailing address. He's to have no contact with or go on the property of H&W Auto Sales while these charges are pending. Court has signed that order. Mr. Ray, the bail amount is quite low, so I don't know if you're going to be able to post that or not. If you can't, then we'll talk to you again on Friday. If you are able to post that, then we'll see you at our next community court calendar on September 8th at 10 a.m., okay?
But that's what I'm saying. What if, could I have my medical appointment on Wednesday, the 8th? Well, Wednesday, it's coming up Wednesday for my medicine. So what if I'm not here? What if I miss that? That was a hard date to get. That's why I keep asking you, Arnie, before you use that gavel, make that bill.
This is the heart of the battle. The prosecution wants a $500 bail, painting Mr. Ray as a repeat risk who can't stay out of trouble for even a week. The defense counters with something very different. Release him on his own recognizance, check. In more often, and let community court do its job. Notice how they frame the new charges. They're just allegations, non-violent, and Ray even has a mental health appointment lined up. Here's the tension. Should the court prioritize public safety with stricter bail, or rehabilitation with a chance at treatment? What do you think? Does Mr. Ray deserve another shot, or is the judge right to lose patience?
I will make that bill. Please let me out there because Wednesday it's so hard for me to get that medication appointment. That's like the really hardest. Without medication, I'm out the walls. I'm self-medicating on a lot of things. And
Mr. Ray, I'm gonna advise you to hang tight.
If you gotta understand, no.
Mr. Ray, bail is very low, so see what you can do about posting it.
It's not fair. It's not fair how they put trees speak. It does me. Okay? They got me kicked out of my room.
Mr. Ray, bail is very low, so what you want to do is see if you can make arrangements to have that posted, and if not, then we'll be in communication to see what we can do about getting you released.
It's not fair. It's not fair. I'm not a bad guy. I'm not. This is not fair to me.
Mr. Ray, see what you can do about posting bail.
What's up with me for harassing me? It was still me in my own room. And it's so hard for me to get this medication appointment on Wednesday.
Mr. Ray, if it comes down to it, we can contact South Sound Behavioral Health and try to figure something out. Okay?
Huh?
I'm going to see what we can do about contacting South Sound Behavioral Health for you. You see if you can post bail, and you know that I'm going to do everything in my power to make sure you're taken care of.
That's what I'm saying. My parents are out of town.
You know I've helped you out before, so I mean it. I'm going to follow up with them and make sure we get all of your appointments settled, okay?
My parents are out of town. They can't post bail. They're not going to want you because it looks bad. My dad's
I'm going
like,
to do my best for you, Mr. Ray, okay?
You did email.
Is that it for Mr. Ray's hearing?
Yes, Mr. Ray, thank you. You can go and let the officer know that you're all done.
When's the next court date I have it here again?
Your next court date, if you're still in custody, will be on Friday. If you're out of custody, it will be on September 8th.
On Friday?
Yes. Yep. If you're still in custody, we'll see you on Friday.
Okay.
And there it is, the ruling. The judge follows the prosecution's recommendation, $500 bail, release on recognizance for the other matters, and a strict no-contact order with H&W Auto Sales. In plain terms, Ray still has a pathway back into community court if he can get past this bail hurdle and stick to his mental health treatment. But the court made it crystal clear, this is his last warning. Any more slip-ups, and the patience runs out. The real question now, can Ray follow through, or will history repeat itself yet again? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.